Good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, The Financial Planning Aspects of Estate Planning, with our presenter, Senior Principal and Estate Planning Team Leader, Olivia Holcombe-Volke of Elville and Associates. So briefly, if you haven't joined us before, if so, welcome. We're glad you're here. The way this will work today is you as the attendee are in listen-only mode. However, there is a questions panel on your screen where you can ask questions and interact with me throughout the presentation. And we'll pause to field those questions throughout as well as at the end of the presentation. You received the presentation for today from me by email yesterday. However, if you did not receive it for some reason, there is a place on the panel that's called handouts, so you can download that presentation at any time for your convenience to take notes on it if you wish. Also, for our certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So if I don't have your information already, for my records, please email me your board ID, and also for CFPs only, I need your social security number, the last 4 digits of your social security number, as soon as possible. And I'll also be sending out CPA certificates soon after the webinar. Everyone will also receive a post-webinar feedback email right after the presentation. And we ask that you please take just a couple of minutes to fill out this simple survey to offer us your valuable feedback about the presentation and share some ideas about presentations you'd like to see us offer. And you also have the opportunity to request a time for a consultation with Olivia to discuss your planning needs. And we always look forward to being a resource to you here at Elville & Associates, and there is nobody better to guide you through your planning than Olivia here at the firm. So briefly, I'd like to share some information about our firm as well as Olivia. Just take a minute or two, and I'm gonna share my screen here and start this. So we are Elville & Associates, founded in 2010 in Columbia by managing principal and lead attorney Stephen Elville, who did a webinar yesterday for us about estate planning essentials. And we do a number of different things here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business and succession planning, asset protection, guardianship and litigation, and tax planning. We have 7 attorneys, 12 staff members in 5 locations. We're coming to you here from the Columbia location in the Gateway community. Our mission today, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We offer a lot of education here at Elville & Associates. We do that through our planning processes with our clients. We offer well over 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program. We are one of only 2 law firms in the state of Maryland to offer an accredited client care program through the Client Care Academy in Boston, Massachusetts, and we're very proud of that. It's a very robust program, offers a lot of additional benefits for being a partner here with us, Elville & Associates, and a lot of our clients take advantage of it. Ask me about it further if you'd like to with an email. I'll be glad to follow up with you, or just give me a call. We also work with the ideals of client education, collaboration, and compassion with every client, every time here at Elville & Associates. A little bit about Olivia, our senior principal and senior estate planning attorney with Elville & Associates. Her work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. She is a seasoned speaker and presents at numerous workshops, conferences, and continuing education events each year. She was named to the Maryland Rising Stars list by Maryland Super Lawyers in 2017, named 10 Best for Client Satisfaction in Estate Planning by the American Institute for Legal Counsel in 2018 and 2019. And she stays very busy aside from the work she does here at the firm. She is a board member for the Women's Law Center of Maryland. She is a chair for its Judicial Selections Committee and also a volunteer attorney for the Maryland Volunteer Lawyers Service, was a founding member for the MVLS's Community Advocacy Network, and also named as the Volunteer of the Month there in 2019. and also provides trainings to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So it does a lot of volunteer work in the community, and we're very proud of Olivia for that. So with all that said, we're going to go ahead and get started here today. And before we do that, I have a little bit of a poll that I'm going to start off with. And that poll, I can find it. I don't think I can find it. I'm just going to have to try to read it in the small writing here on the screen. Is, what is your primary interest in today's topic? So I'm going to go ahead and launch this poll, and you can choose the answer that best describes you. And the choices are, I have no planning, and I felt this would be beneficial to my situation. I have a plan, but my financial picture is not included in that plan. Or I'm an advisor here to learn to better serve my clients. Or lastly, I have outdated documents that need to be updated. So just take a minute to choose what option best suits your situation so we get an idea of who's with us today. It'll take just another second or so. Okay, and with the responses, about 80% having responded, we have 14% saying, I have no planning and felt this would be a good start. 39% saying, I have a plan, but my financial picture is not included in that plan. 31% say, I'm an advisor here to learn to better serve my clients. Welcome to our financial advisors on the webinar today. And 17% saying, I have outdated documents that need to be revised. So we appreciate your responses. I'm going to close that poll out now. And with that, thanks for participating in that poll. I'm going to turn the presentation over to your presenter, Olivia Holcombe-Volke, person you came to hear talk today. Olivia, it's all you.
Thank you so much. Great, thank you, Jeff. Let's see here. Good morning, everyone. Let's get this slideshow started. Okay, so good morning, everyone. Thank you very much, Jeff, for that introduction. I am Olivia Holcombe-Volke, and I'm going to talk today about the topic of financial planning aspects of estate planning. The genesis of this topic is that I realized how easy it is and how common it is for there to be pretty significant confusion about how financial planning and estate planning both overlap, but also are very distinctive areas of expertise. So from many communications with clients, it's become clear to me that it would be helpful to be more clear about how financial planning differs from estate planning, but also the ways in which they significantly overlap, and in fact, very much need to overlap and need to both be taken into consideration in terms of making sure that your financial plan matches your estate plan. So a starting point is thinking through what financial planning actually means. Now, I am not a financial planner. I am not a financial advisor. And so the financial advisors and financial planners to whom I refer clients will certainly be able to go into much greater detail about what financial planning really means. But a very simplistic way of thinking about it is that it is a comprehensive analysis of your goals, your tolerance for risk, your life stage, and any family and health and personal circumstances that are relevant in your life, And then thinking through what suitable investments might be available, including insurance and general savings. Then taking into account budgeting and tax planning, all of which is done for the purpose of making sure you can achieve your financial goals. Very simply put, it means making sure that you have enough money to accomplish both your lifetime and your after-death goals. So then what is estate planning? Well, here it's remarkable how similar this looks. Estate planning is a comprehensive analysis of your goals, your tolerance for risk, your life stage, and your family, health, and personal circumstances, plus taking into account your financial or asset picture, and then thinking about what are the suitable legal documents to help you achieve your estate planning goals. So to do a brief review of estate planning, because one of the things that I regularly hear people think is this is relevant only to what happens after my death. Estate planning is more than that. Estate planning covers not only what happens with your property at your death, it also covers what happens to your property and your health if you are still alive but need help, particularly if you become incapacitated. So estate planning covers having the appropriate legal documents to plan for the care of your health and your assets while you're still living in the event you needed help, and planning for the appropriate disposition of your property after your death, including planning for the protection and care of those who may be dependent upon you. Simply put, estate planning means having the necessary legal documents to dictate not only who you want to handle things for you if you are unable to, whether because of incapacity or death, and how you want things to be handled. So how do financial planning and estate planning overlap? Well, the starting point in both of the outlines of what financial planning and estate planning mean, goals. We see the overlap in what are your goals? And the second question being, how do you plan to finance them? So how you plan to finance your goals is something that a financial advisor will be able to help you think through and plan to be able to accomplish. And then how will you ensure that your goals will be respected and accomplished in the event you are unable to do that for yourself? And here's where the estate planning documents and the legal structures come into play. So a few examples that I think are helpful and enlightening in terms of thinking about this three-step approach and dovetailing financial planning and estate planning. So my first example, a goal that I regularly hear, I wish to age in place. The question then becomes, how will you finance that goal? So here we would want to take into account your family medical history. Of course, none of us have the ability to predict the future or to know what our life path will look like from a health and medical perspective and an age perspective. But taking into account your family medical history and lifespan, average lifespan in your family, and thinking through your projected costs. What is the standard of living that you're accustomed to or that you want? What are the costs in the area where you live? What are the costs for at-home health care? And what are your available options for paying for such costs? Thinking through long-term care insurance as one financial vehicle, thinking through available government benefits that you might be eligible for to help pay for such costs, thinking through your ability to privately pay for such costs, and really analyzing with the help of your financial advisor, what are the best uses of your money and the best investments that you can make now toward that future goal. And then it's vital to make sure that you have the necessary legal documents in place to ensure that you've not only empowered an appropriate person to take the actions necessary in some future situation where you may not be able to take those actions because you're incapacitated potentially. You want to make sure you have the legal documents not only giving someone else the authority to take those actions on your behalf, but also outlining and clearly mandating your intentions in terms of wanting to age in place, wanting assets to be used in a particular way. All of that is built into the necessary legal documents to help you accomplish that goal. Another example, I've had people who have said, my goal is that our family cabin will stay in the family after I die. Well, the financial aspect of this is, how do you intend for the costs and the maintenance and the taxes and other expenses associated with that to be paid? After you're gone, you want to make sure that that asset remains, but how do you plan for the people who are going to be left after you to pay for the costs of keeping that maintained and keeping that in the family? So you have to think through that and plan for that. And from the legal perspective, thinking through what legal documents and legal structures do we need to have in place to ensure that that goal is accomplished even after you're gone. Perhaps having some sort of trust plan is the appropriate answer, and typically it is. Another example, having your assets add to or supplement available government benefits that may be available for your child or your grandchild who has special needs. Well, the financial analysis of this is, how much money is your child or grandchild likely to need? And how are you planning to have enough assets to fund that after you're gone? So investing properly or having the appropriate financial vehicles to help you ensure that whatever amount it is that you believe your child or grandchild will need, to the greatest extent possible, making sure that you have that asset available to leave for their benefit. But the important thing from the legal document structure and the estate planning structure is, we absolutely do not want to leave assets directly to your special needs child or grandchild, because that in fact will not work to supplement government benefits that they may be eligible for. That very likely will knock them off of eligibility for those government benefits. So the appropriate legal documents and legal structure are the necessary trust planning documents to make sure that the assets that you leave for them will in fact supplement the government benefits rather than replacing them. One more example, goal. Minimizing tax consequences after death. Now that's a common one. I have yet to meet anyone who is not interested in minimizing tax consequences. So one of the financial vehicles that is often utilized to deal with tax consequences after death in such a way that those taxes will be paid without diminishing the value of what after death beneficiaries will receive. One of the typical devices is to purchase life insurance The idea being that the death benefit can be used to pay whatever taxes are due, and that would leave then the remainder and the bulk of the estate to go to the beneficiaries. Well, it's vital that we handle that properly from the legal document structure and the legal structure in order to make sure that those death benefits from the life insurance don't actually add tax consequences, don't actually increase the amount of taxes that may be due. And so that requires making sure that we dovetail the financial planning aspect with the estate planning aspect to accomplish the goal of minimizing taxes. The phrase asset alignment is something that it says a lot simply in the two words. It's about aligning one's assets. But what does that really mean? And what is it that we're aligning assets with? So asset alignment, it simply means ensuring that your lifetime and your after death access. And of course, for you, we're not talking about your after death access. That would be freaky. What we're really talking about is making sure that your intentions in terms of lifetime and after death access to and the distribution of your assets are properly aligned with your intentions. So asset alignment just means making sure that whatever your intentions are in terms of your assets, both while you're alive and after your death, it's making sure that your assets, your specific assets, are actually aligned with those intentions. The reality is that the way that assets are owned and the way that assets are beneficiary designated or otherwise have great impact on lifetime access and what happens after death. And so we have to make sure from a holistic macro perspective, we have to make sure that the way that your assets are structured, both ownership and beneficiary designation, is actually in alignment with your intentions. And that requires a macro analysis. Sometimes steps are skipped and asset alignment is not done from a holistic perspective, but is instead done in a very narrow skipping steps, sometimes in what's viewed as simplifying things. But I am going to talk about the ways in which that can backfire. So for example, I've had many people say, well, I just made my daughter a joint owner on all of my assets. And by doing that, I've made things simple. She can access my money to help pay my bills if I need her to. And then when I die, it'll be her account, no need for probate. And look at this, I didn't have to pay for an estate plan. I skipped a step and I saved myself some money. Now, I am all for saving money, and I certainly am not here to discourage people from doing that. But the risk in doing things in a simplistic way is that in this particular example, simply making your son or daughter a joint owner on all of your assets, you aren't perhaps taking into account some of the risks. So for example, with joint ownership, you are now risking that your daughter's creditors have access to your account. When you add your daughter's name to your account, you also add your daughter's creditors. And that can be anything as simple as she causes a car accident and gets sued, or she's going through a divorce. You have now added her creditors to your account. which of course was not your intention and certainly should not be your intention. Another risk of adding someone's name to your account is that you are actually making a gift to that person, and there may be capital gain tax issues associated with that. And that, of course, is never your intention. And that's just another example of a risk where you may be accomplishing your lifetime intention and maybe your after death intention by adding someone to your account. But you're also taking several risks of negative consequences that probably are not in keeping with your intentions. And what we can do with the appropriate estate plan is accomplish your intentions without adding those risks of negative consequences. Another example of a common simple approach, but that comes with risks of negative consequences, is I'm just going to make all of my assets beneficiary designated or payable on death to the people that I want to inherit. And now I don't need an estate plan. I don't need to worry about these complicated legal documents. Everything's simple and easy. That may be true, but what if at your death, someone that you have made an account payable on death to has already died? Now your asset is in fact going to have to go through probate because the person that you had designated for it to go to has already died. So now your asset will have to go through probate. And if you didn't do an estate plan because you thought you didn't need to, now your probate estate may not go where you intend for it to go. It may not end up going to the people that you actually want to receive it. That's one of the risks. People often say, well, if someone dies who I've designated my account to, I'll just update my designation and designate it to someone else. What if you've become incapacitated at that point in time? Then you can't necessarily update the designation on your account. So there are just many risks that come in from doing it in a simple way instead of having a more comprehensive, robust estate plan that takes into account various contingencies and addresses what you want to happen if this, then this. Typically, rather than doing anything this simplistic to avoid probate, my recommendation is that we discuss doing some sort of trust plan. Another risk of saying all of my assets are payable on death is that the people that you've designated them to at the time of your death may be going through some sort of creditor situation or going through a divorce. And now your money instantly goes to that person and instantly goes to that person's creditors. So there are just various ways that we can be more careful and precise in the planning for an unknown future if we actually utilize a robust estate plan. Another common thing that I hear is the idea that I have a will or I have a trust, so that covers everything. All of my assets are controlled by my will, or all of my assets are controlled by my trust. The reality is that that is not true. And so here's another example of why the asset alignment from a macro perspective is so important. And another example of why there is significant overlap between the estate planning legal documents and the financial planning asset structures, and why it's so vital that the estate planning attorney and the financial advisor work together on behalf of clients. Because it is not true that a will or a trust actually control all of your assets. Some assets have beneficiary designations, such as qualified retirement accounts like 401ks or IRAs, or life insurance. Those are assets that are controlled at your death by what your beneficiary designation form says. And that's where we have to make sure that that beneficiary designation on those assets mirrors or aligns with your estate plan, so that those assets at your death will properly flow according to your intentions, but those will not be controlled by what's said in your will or your trust. And there are times where it may be wise to have an account be payable on death or transferable on death, or sometimes there are jointly owned assets. And when there are those types of assets, we have to take that into account when we're thinking through what is it that the will actually controls versus what it doesn't. What is it that the trust actually controls versus what it doesn't? And how do we make sure that your intentions are accomplished, not only in terms of what is controlled by your will or your trust, but also in terms of the outside assets that may have other structures? We just have to take it all into account to make sure that from a macro perspective, your goals and intentions are actually going to be accomplished. So, what is a successful estate plan? Well, it's step one, having the appropriate legal documents in place, which include powers of attorney. Those are the documents, both health and financial, that are relevant while you're alive and that make sure that your intentions in terms of who can act on your behalf in terms of taking care of your health and your money in the event that you need help or you're unable to, and allowing you to dictate what powers that person has. Not only what authority they have, but also what authority you want them to have and how you want them to use it. And also making sure that you have the appropriate after death document, whether that's a will or a trust or both. It's all a matter of discussing which of these legal documents are best to accomplish from a legal perspective your estate planning goals and intentions. But the second step of having a successful estate plan is vital. It's as vital as the legal documents. It's making sure that your assets are actually aligned with the plan. So making sure that ownership or titling on your assets is in alignment with your estate plan and your intentions. Making sure that your beneficiary designations are in alignment with your estate plan and legal documents. And of course, the same thing for any payable on death or transferable on death registration. The key starting point for a successful estate plan is identifying your goals. That is step one. And then determining the best mechanism to accomplish those goals. There may be multiple options for getting from point A to point B, but we have to think through what are the pros and cons of those various options and which option has the right mix of pros and cons for you and your particular goals. There is no one right type of plan. Not every plan is the same. Not every plan is appropriate for every person. But the most likely to be successful plan is one where we have taken into account all of the relevant factors and determined which legal documents are appropriate and how do we make sure that the particular assets that you have are properly aligned with that plan to ensure that they will actually flow according to your intentions. To talk a bit about some nuances on beneficiary and payable on death, transferable on death designations, the when, why, and how, Because something that I've said is I never recommend that people rely solely on doing this sort of asset structure as their only estate plan. But that doesn't mean that there is not a place for beneficiary designated assets or payable on death, transferable on death designations. So talking through that a little bit more. First, it depends on the type of asset. So for example, life insurance is a type of asset where at death, it's going to go where the beneficiary designation form says that it is to go. So life insurance is a type of asset where we absolutely utilize the beneficiary designation to dictate where that money will go at death. Here, it's important that we do so in a precise way because there are aspects of life insurance that are relevant to whether your creditors can make claims against the death benefits. Also, inheritance tax, which is a particular type of tax in Maryland. There are times when inheritance tax may be applicable in your estate plan, but if we utilize life insurance, we may be able to get around that inheritance tax. So that's one type of asset where the beneficiary designation is the appropriate way of controlling where it will go at death, but we still have to be very nuanced and precise in terms of how do we beneficiary designate that asset vis-a-vis your estate plan to accomplish your goals in the best way possible. Another example of a type of asset where we absolutely rely on using the beneficiary designation to control where it goes at your death is with any qualified, tax qualified, or tax deferred accounts, like 401ks and IRAs and anything of that type. With these, it's vital that the beneficiary designation be complete and kept up to date because those types of accounts are very nuanced from a tax perspective. And so we have to be very careful and very precise in terms of making sure that the beneficiary designations are done properly, taking into account the income tax consequences on those types of assets and the different beneficiary income tax consequences that are relevant. And just making sure that we're doing so, taking all of that into account in order to accomplish your estate planning intentions. With those types of accounts and assets, we also want to think about creditor or asset protection considerations in terms of the beneficiaries who will receive that type of asset after your death. Checking accounts are ones where we may sometimes advise clients to make those payable on death. But typically when we do that, it's because the client is utilizing some sort of trust as their estate plan. And what we don't want to do is cause too much headache for the client while they're still living. And usually with a checking account, people have their income set up to come in automatically and their debts to go out as automatic debits. And we don't want you to have to update all of that. It's quite a headache. And usually a checking account is something that the balance never gets that high. It's in and out on a monthly basis. So that's one type of asset where we will guide clients to simply utilize a payable on death designation. But usually with that, it's to make it payable on death to the trust. So those are some explanations and examples of where there are different types of assets that are absolutely appropriate for using beneficiary designations or payable on death designations. But hear what I'm saying about using those types of designations in concert with the bigger estate plan and the bigger legal structure. Jeff, do we have questions? I see that there's a bubble flashing.
Thank you, Olivia. We just received our first question here just a minute ago. So thank you. You're right on time. So a question from one of our advisors out here saying, not sure if Olivia will address annuities, but they are a means of protecting assets from creditors. So more of a statement rather than a question.
Thank you. Well, so absolutely, and that statement is very helpful and enlightening, and a very good example of the benefit of using not only the guidance of a legal professional in terms of estate planning, but also the benefit of using the professional guidance of a financial advisor who is able to help guide you on that particular information. You know, people ask me, are annuities a good idea? Should I get long-term care insurance? All of these sorts of questions where my answer is, I am not the appropriate professional to guide you on that, but I highly recommend that you do talk to the appropriate professional, which is a financial advisor, and they will be able to guide you on, based upon your assets and your goals, what are the appropriate financial vehicles and investment vehicles for you to utilize to accomplish those goals. And then my job as the estate planning professional is to work with the client and the financial advisor to make sure that those investment vehicles and those financial vehicles are aligned with the appropriate legal documents to also ensure that the client's goals are accomplished. So as far as commenting on annuities, that's about as far as I go. And for anything else, I usually defer to the financial advisor specifically.
Sure, understood. And thank you for that. And we do have one more question that just came in. So again, everybody, please, bring your questions. You have Olivia here as a resource, so please go ahead and use her. So the next question is from one of our guests here, and she says, POD checking account, is this taxed as income? So can you comment on that, please?
Well, I guess my quick and easy answer is no. I'm assuming that the question is the recipient of the checking account at your death. Are they taxed? Is there income tax to them on that? And the answer is no.
So that's the way that I would look at that question, Olivia. Maybe Melissa, if you could maybe comment a little bit further if you want further clarification of that, that'd be great. But yeah, I think that's the way I would look at that.
Absolutely. And to oh, go ahead, Jeff.
Yeah, go ahead. I'm sorry, we just had another question, but go ahead, please.
Sure. So one thing that I'll say about that question is that a common thing that I find is that the word tax is, of course, something that we are all intimately familiar with, but there are many different types of tax. And so when we're talking about estate planning and kind of the relevant considerations in terms of estate planning, there are really three main types of tax that play a role in that. And so just the word tax isn't, I always try to get narrow and really focus on the different types of taxes that are relevant in terms of an estate plan and to whom and when those are relevant. And so that it can help people not worry about tax that they really don't have to worry about because it won't be relevant to their particular estate or estate plan. And so the three main types of tax that are relevant are estate tax, inheritance tax, and income tax, which includes conversations about capital gains. Those are the three main types of tax that are relevant in the estate planning context. And it's important when we're talking through your goals, your assets, we also talk about which taxes are relevant in terms of your goals and your assets. And then that helps guide us in the direction of the appropriate estate planning documents and the appropriate asset alignment to minimize whichever taxes may be relevant. So go ahead, Jeff, another question? Jeff?
I apologize, I was on mute there because we have some people talking in the hall, so I apologize. So the next question is, and you did hit the nail on the head with where you were going with that previous question, so thank you. The next question is, a parent has a $50,000 interest-only loan to their daughter. What actions can be taken to avoid probate on that note?
Well, that's an excellent question, and the answer is that whenever I'm talking with clients who are interested in avoiding probate, we have to have the conversation about trust planning. And when we do trust planning, one of the things that we do is we have clients sign a document that's called an assignment of intangible personal property. And what that document says and how it works is that it basically says, at my death, if there's money owed to me, it is owed to my trust. So that very simple mechanism is how we make sure that any outstanding debt on a promissory note doesn't have to go through probate. A very easy example is it is common for people to receive tax refund checks from the IRS or the Maryland Comptroller. After death, a tax refund check may come. And the way that we want to avoid probate on that is the same idea. You've signed an assignment of intangible personal property saying that any refund or debt owed to you at your death, it's owed to your trust. And that avoids probate on that type of an asset.
Okay, thank you. Another question or two, and a question from one of our good financial advisors here on the call. Thank you very much. Given the Secure Act's new requirement for child beneficiaries to distribute tax qualified assets within 10 years of inheritance, what are some available estate planning options to help?
Absolutely. Well, that's a great question. And actually, if I may, I'm going to cover that a lot more in one of the next few slides. So I will answer that question shortly.
Okay, sounds great. And one more, what is the best way to handle assets inside a home? I don't have kids, but my husband does. Most assets in the house were here before we married. In addition to designating specific items to nieces, what if they are sold? How can they get the money versus my stepkids?
Well, you are certainly in a rather complicated situation, but it is not insurmountable. It is common for people to have blended families and situations where it may be a second or a third marriage, and we just have to be very precise in terms of the estate planning documents and language. Because of course, the end goal is not only to make sure that assets go to the recipients that you intend, but also to minimize any opportunity or likelihood for litigation. The last thing that anyone wants is for their after-death intentions to result in all of the assets being used to pay attorneys to battle it out in court over who gets grandma's sterling silver platter. And so what we want to do is to be as precise and structured as possible in the planning documents themselves to make sure that that risk is minimized. So to answer your question specifically, it is a difficult thing when we're talking about the stuff inside of the house, because what's called tangible personal property, that's a more difficult thing to address simply because there's less clarity regarding ownership. There's no document that shows title to a couch. And so it can be quite complicated to be really precise and controlled in terms of those specific tangible personal property assets. But really, it's a matter of we just have to talk through all angles of that, because part of it is you may own this particular piece or object now, but you don't necessarily know for sure that you're still going to own it at death. You may have otherwise dealt with it. And then there's making sure that if you do actually own it at death, that there's clear control and precision in terms of who has the ability to come in and touch and distribute things, and how they identify what you mean when you're saying, I want this object to go to this person. So to answer the question, I would just say that requires careful and precise language and structure and really thinking through all aspects of it, which is something that's best done with the guidance and help of me or some other estate planning attorney. So it can be done, but it does require very careful analysis and legal structure.
Okay, thank you, Olivia.
All right, very good. So I'll keep going. So I was talking about beneficiary designations or payable on death, transferable on death designations, and thinking through when are these appropriate structures to utilize, why and how. So I talked a bit about sometimes the answer to those questions depends on the type of asset itself. Life insurance and tax qualified accounts being two examples. Sometimes it depends on the type of estate plan that someone may use. So for example, if the type of estate plan that someone has chosen to use is a lifetime trust, so for example, revocable living trust, in this case, this usually involves our approach to asset alignment using a mixture of beneficiary or payable on death designations, as well as other asset alignment structures. So what we'll typically do when we utilize some sort of trust plan, we will actually change the owner on many of the assets. We will retitle the owner on many of the assets so that the owner is actually the trust. But there are certain assets that we will not do that with, and that's where we have to make sure that the beneficiary designation or the payable on death designation still is in alignment with the trust plan. So usually when we utilize a trust as the estate planning document, we're doing some mixture of beneficiary designated assets and retitled assets as the asset alignment for that estate plan. But it always involves doing it from a macro perspective, taking into account all of the assets, the different types of assets, and the actual plan and goals. Another type of estate plan where we may rely heavily on beneficiary designations or payable on death designations is if it's just a really simple plan. If there are minimal assets and minimal risks involved in the plan, then it may mean that we utilize more of the beneficiary designated or payable on death designated assets. If there are what are called testamentary trusts, which is where there is going to be a trust that comes into existence after your death under the terms of your last will and testament or under the terms of your lifetime trust, those are called testamentary trusts. If your estate plan involves that type of further testamentary trust as part of your plan, we have to make sure that your beneficiary designated assets and your payable on death designated assets are properly designated to take into account those testamentary trusts. Or perhaps you have an entirely separate trust, but you're not planning on having any money go into it until after your death. You've created this standalone trust for the benefit of one of the people you want to care for after you're gone, but you don't plan for any money to go into that trust until your death. And here again, we have to just make sure that any of your beneficiary designations or payable on death designations correlate properly and align properly with that type of estate planning device. And with this, it's a matter to not only of the type of asset that is involved, but it also frequently involves the particular financial institution where that asset may be held. Different financial institutions have different rules and requirements and procedures. Some can make things more complicated than others. I know we all have familiarity with that. And here again, it's a primary example of where your financial advisor can be so helpful in terms of helping navigate the particular requirements and nuances of the financial institution that may hold your assets. So the third thing that I'll talk through about beneficiary designations and payable on death designations is thinking about it in terms of your specific beneficiaries. So who is it that you specifically intend to receive money from your estate after you're gone? Who or what? Maybe it's a charity. But what are the specific beneficiaries that are part of your intended estate plan? And what are their particular nuances? So we have to take into account, is it a spouse or a non-spouse? Is it a trust? And if so, what type of trust? And even further than that, who is the beneficiary of that trust? We have to think about whether there are special circumstances. Do we need to worry about the beneficiary needing creditor protection or needing some sort of structure where they can't actually control the money for themselves, or needing to protect the beneficiary's eligibility for government benefits, needing to take that into account? Or is the beneficiary currently a minor? And what if you die and they're still under the age of 18? Making sure that all of this is structured to actually work properly in accordance with your intentions, but taking into account the nuances of the specific beneficiaries that you actually want to inherit from you. Because depending on those beneficiaries and their nuances, we need to structure things in certain ways. And that very much takes into account beneficiary designated assets. Questions at the moment, Jeff?
Thanks, Olivia. We do have a couple of questions, and the first one is, how does one designate a house in Maryland to a beneficiary using only a will?
So, thank you. And I've covered in other webinars, I cover in more detail the nuances between a will versus a revocable trust. So I highly recommend, those are available on our website, highly recommend that you listen and watch those, because it really goes into a lot more detail about the different devices that you can use and the different details that are relevant to them. But to answer your question, and part of what I'm hearing in your question, let me go into a bit more detail. So you can designate whatever you want in your will. What matters is, what does the will actually control? So here's where there's often confusion and misunderstanding about that. So what does the will actually control? The will controls your probate estate. That's all that it controls. It does not have relevance to other assets. It controls only those assets that you have that go through probate at your death. Well, what assets go through probate? Assets that have no living owner, because if you were the last living owner and you died, now there is no living owner, and that do not have a beneficiary designation. So as I said, life insurance and 401k IRA accounts, those have beneficiary designations. So that's where those monies will go. Your will not control those monies as long as you've done the beneficiary designation properly. So for a house, if you're the last living owner and you die, then the house goes through probate. And if you have a will, the will is what the probate court relies on to tell them where you want your stuff to go. So in your will, you would say, I want my house to go to this beneficiary. Or you simply say, I want all of my probate estate to go to this beneficiary, and the house would simply be part of that. So I hope that answers the question. Please clarify if it doesn't, but yes, you can certainly designate in your will where you want your house to go. But to be clear, the will is only relevant to probate, and probate is only relevant to assets where we have no living owner and no beneficiary designation. And in that case, your will applies to what happens in the probate court.
Okay, thank you. And the next question, I did reach out to get some further clarification for this question, but haven't yet heard back. And the question is simply, how should vehicles be titled? And I asked if that meant to avoid probates, etc., but haven't yet heard back. Don't know if you have any general comments about that statement.
So what the first general comment that I'll make about that is that's indicative of exactly what I'm emphasizing and emphasizing and emphasizing. The starting point always needs to be, what is your goal? What is your goal? And then we are able to work backward and think through, if this is your goal, then what is our best way to accomplish that goal in terms of the actual specific assets that you have, or the specific asset for which this specific goal is relevant. It allows us to work backward and identify, what are your assets, or what is this specific asset? What is the structure of this asset? How is it currently owned? How is it currently beneficiary designated? So we know what your end goal is, then we figure out what is the relevant aspect of this particular asset. And we also then think through, what is the best way to accomplish the goal with this particular asset, while also minimizing risks and negative consequences that you may not have thought about, or that you may not be aware of. And so what is the best mechanism from the legal structure standpoint to accomplish your goal with this particular asset while minimizing risks and negative consequences? So it's a difficult thing for me to answer that question because I don't know what the goal is. But that's something I would say again, is that this is why it's so important to talk to an estate planning professional and a financial advising professional so that we can help make sure that all of those bits and pieces come together to form the complete puzzle to succeed in accomplishing what your goals are.
Right. And the goal for that would be, and I just got some feedback, would be to avoid a probate situation.
Well, so with cars, so first of all, anytime someone says avoid probate, my response is let's talk about whether a trust is the right approach for you. Because if it is, so utilizing a trust is almost always my answer to how to avoid probate. So I always want to welcome the conversation about whether a trust is appropriate for a particular client, because answering it in a more simplistic way always worries me, because as I mentioned in previous slides, doing it in a simplistic way opens the door to many risks and many negative consequences. So my answer to I want to avoid probate is we need to talk about utilizing a trust. And in terms of that, specifically with regard to vehicles, it's either a matter of we guide clients to actually retitle the car into the trust, or Maryland actually allows TOD on vehicle titles, which is transfer on death. And that's something that Maryland does allow, and that's sometimes the right answer.
Okay, thank you. And last question, and it's along the same lines, but just a different vehicle here. And the question is, can't a house be put in a trust? And does it change the title?
In order to put a house into a trust, we have to change the title. So yes, we regularly deed houses into trusts.
Okay.
Yeah.
And that's everything for now. Thank you, Olivia.
Okay, sure. All right. Okay, so to answer the question that was asked a little bit ago, what does the statement, don't leave your 401k or IRA to your minor child or grandchild, what does that really mean? So this is something that I hear, and actually I frequently hear this as something that financial advisors are telling clients. And so that's a reason I'm mentioning it on this presentation, because I want to get more precise than that. This is a simple statement, and it comes from a good place, but let's talk about it in a much more nuanced way, because what I don't want to happen, if someone's goal is for their 401k to go to and for the benefit of their grandchild when they die, I don't want to deter them from accomplishing that goal without having a more nuanced conversation about the pros and cons, the risks, the nuances, the ways in which we can actually accomplish that goal. It just may be a bit more complicated. So it may be that once someone has had the conversation, taking into account all of the factors that they need to think about, it may be that they decide, you know what, never mind, I don't want to leave my 401k to my minor grandchild. But I only want them to make that decision after they know what the options are and decide whether the more complicated option is still worthwhile to them in order to accomplish their goal of leaving that asset to their minor grandchild. So let's talk through that, and also we'll talk a bit about the Secure Act. So the complication with regard to a minor inheriting assets is that someone under the age of 18 cannot legally own property. So if a 15-year-old inherits property, it's going to require that a court guardianship matter be opened up, where the court actually appoints a guardian to be responsible for that inherited asset on behalf of the minor until the minor turns 18, at which point they get it. So there are multiple negatives, in my opinion, to that. Number one, we always would like to avoid the court's involvement. That's just a good starting point. But number two, even at 18, most people would agree we don't want an 18-year-old to be in charge of a large sum of money, that's probably not the best idea. So the complication in terms of a minor inheriting assets is that it will require court involvement unless the appropriate planning is done ahead of time. And that's what I'm going to talk about. So that's a complication of a minor inheriting an asset. And the risk is that we don't necessarily want them to be able to control that amount of money immediately at the age of 18. Now, before I talk about the other options, another thing that I'll say is that I've heard many people say, well, I'll just leave it to someone else instead, and then they know that I want them to use that money to take care of the grandchild, or they know what I want them to do with that money, and I trust that they'll do that. This is not ever a good idea for several reasons. Number one, the actual recipient of the asset is the one that will face the tax consequences. So the actual recipient of the asset is how the tax consequences are determined. And so if your intended beneficiary wouldn't face those same tax consequences, you've now opened the door to tax consequences that otherwise wouldn't be there. Another risk is that the person who actually receives the asset, it's now theirs. And whether or not you have a gentleman or a gentlewoman's understanding that they will use the assets in a particular way, you have no guarantee of that. And they may have good intentions, but what if they get sued? Now that asset is theirs and can be taken. Or what if they lose their mental capacity and now someone else is managing things for them, and that other person says, well, I'm not using this to pay for this child or other beneficiary. I'm using this to pay for what my person actually needs. So there are just many different ways that that can backfire. So the risk in designating assets to someone else with the understanding that they will use those assets for the actual person that you intend to benefit from them, that's never a good idea. There's always a better way to plan and a better way to structure. So what is the solution? The solution is to make sure that what you have built in your estate plan is that your minor child or your minor grandchild or whomever it may be, if they're a minor, or if there are any other considerations that we need to worry about. What we're talking about is that what you're actually going to be leaving for their benefit is going to be in trust. So you are leaving your assets for the benefit of your minor child or for the benefit of your minor grandchild, but you're not leaving it directly to them. You are leaving it to a trust for their benefit. And by doing it that way, you get to dictate who is the trustee, which simply means the person who is responsible for carrying out the terms of the trust, which means using the assets for the benefit of your minor child or minor grandchild. So you get to decide who actually is in charge of carrying that out, but they're controlled by the fact that they're just following the terms of the trust. And you have said in the trust, this is to be used for the benefit of this person. So in that situation, the trustee is not considered to actually own the asset. So if they get sued or if they become incapacitated, that's not going to harm your intentions. And it doesn't mean that the taxes would be attributed to them. So the appropriate way to plan for assets for the benefit of a minor or the benefit of someone who is disabled or incapacitated, or the benefit of someone who may have creditor issues in the past or the future, the appropriate way to plan for money that you're going to leave to them is to plan for it to be held in further irrevocable trust for their benefit. Now, in terms of the Secure Act, the Secure Act is a sweeping legislation that passed at the end of 2019 that deals with inherited IRAs, inherited 401ks, any of those sorts of inherited tax qualified accounts. And what the Secure Act did is it significantly changed how those inherited accounts are taxed, depending upon the specific beneficiary. So the Secure Act dictates, depending on the particular beneficiary, in what amount of time do they actually have to liquidate the inherited IRA and pay the income tax. And it's different depending on the beneficiary. So it's different depending on whether it's a spouse or not, a trust or not, different types of trusts, the beneficiary or beneficiaries of those trusts. Is it a qualified disabled individual? Is it a chronically ill individual? Is it a minor child? Is it someone who is less than 10 years younger or within a 10-year age range of you, the account owner? All of those have different results in terms of the tax consequences on inherited IRAs. And it is what it is. There's strategies that various people are implementing in light of the change and how that has impacted. The quick and dirty thing that I'll say is that pre-Secure Act, we were able to structure inherited IRAs to be liquidated over the beneficiary's lifetime, life expectancy. And now for most beneficiaries, that has been compressed to 10 years. So in terms of leaving a 401k or an IRA to your minor child or grandchild, or to any beneficiary, it's simply a matter of we have to talk about your particular beneficiary and what the income tax consequences are from the Secure Act perspective with regard to the inherited 401k or IRA that they may receive, and taking that into account as this is how it's going to work under current law. What can we do to structure it in the best way possible to accomplish your intentions in light of the reality of this particular law and its impact? So I see questions, Jeff. Go right ahead.
Well, thanks, Olivia. And we do have one question, and it's a good one. The question is, change of life question. How do I transfer title of property and investments of my incapacitated wife using my up-to-date power of attorneys? I want to use the money for caregiving.
Okay, so say the question again, Jeff. I'm sorry.
Okay, not a problem. How do I transfer title of property and investments of my incapacitated wife using my up-to-date power of attorneys? I want to use the money for caregiving purposes.
So my answer to that question is that I can't comment on what authority someone has under a power of attorney document without actually seeing the power of attorney document, because different attorneys draft them differently and different years they were drafted differently and so on and so forth. So it always requires a specific examination of the actual document itself in order to then be able to answer the question of what power do you have, what authority do you have? But I would also say that in a very simple way, being power of attorney means that you should, again, depending on what the document says, but a baseline of a power of attorney document is that you have authority to access those monies on behalf of your incapacitated spouse to then use those monies to pay for her needs. So whether or not you can change title and whether or not you can do any sort of change of ownership, that is something that really requires seeing what the actual document covers. But in terms of just generally speaking, usually the purpose of a power of attorney is for you to be able to access the monies to pay for what your spouse needs.
Okay, thank you for that answer. And one more question, and the question is related, it appears, to the Secure Act discussion you had just recently. How does that impact if the tax qualified account is left to a non-profit?
Well, it gets really fun, to be perfectly honest, when people have such good intentions, which is that they want money to go to charitable organizations after it may be for the benefit of their other beneficiary. It does get complicated. So the reality is that charitable organizations, as the beneficiaries on tax qualified accounts, charitable organizations do not pay tax. And so they are actually able to receive that money tax-free, which is great. And that really speaks to taking into account from a macro perspective what someone's estate planning goals are, and if that includes charitable beneficiaries. From a macro perspective, it is very wise to take into account all of that person's assets, because there are certain types of assets where there are tax consequences. And since charitable organizations don't have to pay those taxes, it makes the most sense to direct those taxable assets to the charitable beneficiaries. And so from a macro perspective, and part of why that's so important is because that then allows us to make sure that the best financial assets are used to fund those charitable estate planning goals. But in terms of the Secure Act, and where it really gets sticky, is the idea of leaving an inherited IRA, for example, to an individual in trust for that individual's lifetime, and then after their death, that anything remaining would go to a charitable organization. Here's where we do have to be very precise in how we draft the trust documents in order to make sure that that ultimate charitable beneficiary doesn't harm the individual beneficiary at the point in time when they're actually going to inherit from that tax qualified account. So it just adds a level of complication. Thank you, Congress, for doing that. It adds a level of complication that we have to take into account and be nuanced. Again, it's a matter of what are your goals? And here are the risks and pros and cons associated with accomplishing those goals. Here's the way that we can accomplish those goals in the best way possible with the assets that you have and with the available legal documents that we can rely on. Here's the best way we can accomplish your goals, but it may involve some negative consequences. And that ends up being up to the client to decide whether they want those negative consequences in order to accomplish the goals, or whether they want to change their goals to avoid those negative consequences. But it all requires a macro review of all of the details.
Okay, that's everything for now. Thank you, Olivia.
Sure. All right, you guys, not too much more. So thinking about, again, talking about the financial planning aspects of estate planning, and tax obviously being a significant part of this. So one of the things we just talked about, charitable inclinations, If someone has charitable inclinations, which is fantastic, but what we want to do is make sure to leverage your charitable inclinations against any tax that your assets may face. So what is the best way to accomplish your charitable inclinations in a way that will maximize tax avoidance? And this is a matter of looking at your assets and determining the best assets to use to accomplish your charitable inclinations. And it's also a matter of thinking through timing. Is the best time for doing this, for accomplishing these charitable inclinations, is the best time now while you're alive, or immediately at your death, or after some other beneficiary then dies? So that's all a matter of thinking about your finances, your particular assets, and your charitable inclinations and the tax considerations that are relevant. If someone has a large 401k or IRA or TSP, any of these tax qualified assets, we have to think about lifetime income tax consequences and mitigation. And here's where the financial advisor is such an asset, because that's really in their wheelhouse to be able to help you figure out the tax consequences to you of having a large 401k, and what are some options that you have to mitigate those tax consequences. But we also have to really carefully analyze the after-death beneficiaries, your intentions and goals with regard to your beneficiaries. But if you have a large 401k, for example, we have to talk about the tax impacts for those particular beneficiaries, and are there options to mitigate that? We have to think about creditor protection. Something that many people don't know is that while you're alive, your 401k is protected against your own creditors. And after your death, if your spouse inherits it, it also is something that can be rolled over and protected against your spouse's creditors. But non-spouses do not have that creditor protection on an inherited IRA. And so we have to structure it. If creditor protection is important to you, then what we're really talking about is making sure that your beneficiary is actually inheriting in trust, which would bring in that creditor protection over what they inherit from you. It's also always important, as part of the conversation in terms of any estate plan, the idea of, do we need to plan for protection against your surviving spouse getting remarried? And that's just always an important part of the conversation and the planning. And the Secure Act, we just talked about it, but the Secure Act itself is a primary example of the overlap of financial planning and estate planning, and where they really overlap and sometimes crash head on, and how vital it is to have experts from both fields help guide you to accomplish your goals. Long-term care healthcare, this is obviously something that's a concern for many people. Again, one of the things I mentioned previously is when people ask me, should I get a long-term care insurance policy? I always guide them to talk to a financial advisor, because that is an investment. It is an investment vehicle. And so the only way for you to know whether that's an appropriate investment vehicle for you is to talk to a financial advisor who can take into account all of your assets and the appropriate investment of those assets to accomplish your goals. And perhaps there are other investment vehicles with greater returns that would help you privately pay for long-term care health care. And that just requires doing a financial plan and a financial analysis. But in terms of planning for long-term care health care from a legal perspective, it is vital that you have the appropriate documents in place to dictate not only who will be able to make sure that your long-term care goals and intentions are accomplished if possible and to the greatest extent possible. You need the legal documents to dictate who it is that you're empowering to take care of that on your behalf if you can't do so for yourself, but to also outline what power and authority they have and how you want them to exercise it in terms of your goals and intentions for your own long-term health care. And part of this too is thinking about eligibility for Medicaid to pay for long-term care needs and what can be done from an asset protection standpoint to be eligible for Medicaid while still protecting the assets. And there are different legal structures that we can utilize to accomplish asset protection and Medicaid eligibility. And that just requires talking through your goals, your current life stage, your assets, and figuring out which legal structure is appropriate right now and which legal structure may be appropriate in the future. And guess what? If you don't have the mental capacity to do that for yourself at some point in the future, if you have an appropriate, robust power of attorney document, you are making sure that your power of attorney will be able to do that Medicaid asset protection and eligibility planning on your behalf. So it all goes back to making sure that you have a comprehensive estate plan in place based upon goals, intentions, worries, and the actual assets. And finally, again, estate, gift, and inheritance taxes and income tax. I mentioned that these are the relevant tax considerations from an estate planning standpoint. And all that we can really do, educate everyone on which particular taxes are relevant to their particular assets, plan, goals, beneficiaries. We have to take all of that into account in order to be able to specifically identify which taxes may or may not be relevant and what options you may have for minimizing or avoiding them. And this is often just one of many considerations. It's not the only one, and it's often not even the highest priority, but it's part of the conversation. So the last thing that I want to just summarize and say is, from an estate planning attorney's perspective, the benefits that I see from working with a financial advisor, because often people say to me, oh, I manage my own investments and I've been doing fine. I don't want to pay someone else to do something I can do for myself. Here's what I will tell you. There are many, many benefits to come from a financial advisor above and beyond simply making you more money. It's not limited to investments. It's a macro perspective. And the benefits that I personally observe are as follows. You may have perfect control and be quite good at making your own investment decisions. But what happens if you become incapacitated? The benefit of having a relationship with a financial advisor is that that will be a seamless transition, that in the event you become incapacitated and are no longer able to do those brilliant investments for yourself or to make those sorts of decisions, don't worry. You have a professional who has been involved and has been aware and has been part of your overall financial picture, who will be able to continue that in the event that you are not able to do it for yourself. And similarly, after your death, you of course will not be able to continue to do that for yourself. And having a financial advisor with whom you had a relationship, that professional will then be able to really seamlessly help navigate the transition from your lifetime to what happens after your death. The personal relationship helps your family and the people that may be stepping into place as your fiduciary. It helps them to know what you have, where you have it, how you have it invested, all of these details that they may otherwise have absolutely no way of knowing, which will only add to the stress and add to the grief a family or fiduciary dealing with someone who's become incapacitated or disabled, or someone who's died, it will certainly help ease the stress and the grief if they can rely upon a professional who had the insight and the personal relationship with you and your assets to help them navigate that new territory where you're no longer able to be involved. Another major benefit is that they provide objective oversight. People frequently ask me, they're very afraid of giving power of attorney or giving any sort of power to another person over their money and their assets. It scares people, and I understand that. One of the things that I always say is, no, there is no supervisor. There is no Maryland government supervisor or legal supervisor making sure that your power of attorney is behaving properly. They're obligated to behave properly under the law, but there is no supervisor. But one of the benefits that comes from having a financial advisor involved in your financial world is that now you have someone who is paying attention and who will notice if huge withdrawals are being made from your accounts out of nowhere, or if inappropriate behaviors seem to be taking place, and they can raise the alarm bells. So it's just one additional objective oversight option in terms of your finances. And they also, the financial advisor is such a helpful tool to help the estate planning attorney to ensure the success of your individual estate plan, because we work together to make sure that all of the assets that you have are properly aligned to accomplish the estate plan that you have in terms of the estate planning legal documents that are necessary, all for the purpose of accomplishing your goals. And that is it. So the ideal advisory team is one where you have an attorney, a financial advisor, and maybe also a tax advisor. Frequently, the tax advisor and financial advisor really overlap. But these are all areas where professional guidance and professional relationships will really help you achieve your goals and address any worries and concerns that you may have. Okay, Jeff, any last questions?
We have no last questions, but I think we had some good ones there along the way. And just want to thank you, Olivia, as always, for your time and your knowledge, and always appreciate your presentation style, as I think our attendees do as well. This is always one of my favorite webinars to listen to, not only for the really important information that is in it, and I appreciate you thinking of this topic and putting the presentation together, but also just your presentation style and the way that you offer the information, I think is really, really helpful to people.
I hope so.
I'm sure it is. And so just a couple of last thoughts I have. If you need a financial advisor, have been thinking of one, or this has propelled you to say, I need a financial advisor. We know many advisors here at Elville & Associates, and we're very happy to make a warm introduction to you for a couple of advisors that may be a good resource to you. So let us know if you are interested in getting a referral for a good financial advisor, CPA, insurance professional, maybe all one tied into to one person. So just let us know. Olivia would be happy to get that information over to you. Also, if you want to get started with your estate planning, if you have old, outdated documents that need to be updated, if your planning doesn't reflect your financial picture, if you have a business that's not included in your estate planning, let us know, and Olivia would be happy to have a discussion with you about that. Always glad to be a resource for you here at Elville & Associates. So please take a moment to fill out the post-webinar feedback. We always value and look at every one of your comments, always trying to improve here. And a couple last things, 2 webinars of note that are coming up. Next Wednesday, Steve Elville is going to be talking about what families need to know about planning for a loved one with special needs. Always a very important and popular topic that we have here every few months. And on May 12th, for advisors on the webinar today, we're going to be having our advisors forum that we offer every couple of months. And the topic for May 12th is the looming Biden era tax law changes and the For the 99.5% Act. So we'll be talking about that, offered by Stephen Elville. Invitations have gone out. If you didn't get an invitation, that means that you're not on the advisors forum list. So give me an email or a phone call. Email would probably be best, jeff@elvilleassociates.com, and I will make sure that you get an invitation for those advisors forum webinars and workshops going forward. And you can also go on our website on the events page and go to the May 12th event and register as well. But if you want the invitations, email me. I'll make sure you get on the advisors forum email list. So that's everything for today. Have a great day, and we appreciate you being on the Elville webinar series and for your support. Have a great day, everybody.